Number 64 and 65. 64, matter of Verneau versus Consolidated Edison. Number 65, matter of Rexford versus Gould, Erectors and Riggers. We'll start with number 64. Counsel?
Good afternoon. May it please the court. Allison Levine for appellant, the Workers' Compensation Board. May I please have 2 minutes for rebuttal, Your Honor?
You may.
Thank you. The question in this case is whether a state-created fund or the original insurance carrier should be liable for new death benefit claims that accrued after the legislature closed the fund to new claims. This court's decision in Zeckman, the statutory text of the provision closing the special fund, and the legislature's intent in closing the fund make clear that death benefit claims are new claims that cannot now be transferred to the fund and therefore should be paid by the insurance carrier.
But counsel, the statute actually says a liability for a claim, right? It doesn't say claim. If it said claim, I think you have a different argument, but it says liability for the claim. And under Fitzgerald, right, third department case,
Yes.
2011, I think, at the time the statute was passed, the fund had a liability for the claim, a death claim. You didn't have to file a new application. You didn't have to do anything. It was there. So to me, that liability is there, doesn't need to be transferred to the fund. And I'm assuming the fund was operating under that rule in 2013, 2014 when the statute was passed.
It was at that point operating under that understanding, but it was doing so wrongly because that understanding can simply not be squared with this court's decision in Zeckman.
Put that aside. We never decided that, but put that aside. The practice of the agency at the time the legislation was passed was you had liability for these claims. You didn't have to transfer them. You didn't have to apply. It was there. The fund knew that. The fund was involved in the legislative fix, I'm imagining, and yet this language is in there. It would have been an easy thing to address that, especially if you thought it was wrong, but it isn't.
Well, they did have to apply. These insurance companies were applying to transfer these death benefit claims.
Even in the Fitzgerald case.
Yeah, I'm not sure if there was a formal application there, but it was raised before the Workers' Compensation Law Judge, and the Workers' Compensation Law Judge found that claim should be transferred, Your Honor.
But my understanding of Fitzgerald, tell me if I'm wrong, was you didn't have to make a new application to the fund after Fitzgerald. If, let's say, facts of that case, the fund had a claim, they were paying out benefits, they stopped. A certain time later, that person's spouse died. That death claim was in the fund. There was no new application.
No, I believe a new application was made because there was nothing to do. They had to put in an application for death benefit claims, and then either the special fund was put on notice or an insurance carrier was put on notice, and then an application might ensue from there. I don't think it was automatic that the special fund would remain liable for those death benefit
But
claims.
let me ask you this, did you have to separately meet the factors to transfer?
Yes, yes,
At the time of the death claim?
I believe so. Yes.
In which case are you saying that was true?
Fitzgerald, they're
Oh,
referring to Fitzgerald,
yes,
it's a
Fitzgerald.
2011
I'm
case.
not sure that that's correct, but
Yeah.
I might be.
Counsel-
We'll both have to look at it. Go ahead.
Oh,
John.
I'm sorry, I think-
No, you go ahead.
Before we get too far away from the statutory language, liability for a claim is a phrase that's been bouncing around in my head. As it's used in the statute, you started off your argument by saying the death claim is a separate claim, which I assume you mean separate from the underlying disability claim that was made however many years before. So when the statute says liability for a claim, do they mean liability for each claim as you define it? A disability claim, and then a death claim, and then whatever an after-death claim might be? I'm laughing under here if you can't see that. Or do you mean, or does it mean liability for the case?
It refers to liability for the claim, that the statute says transfer of liability for a claim. It refers to the claim, and again, and this court said in Zeckman that death benefit claims are separate and distinct claims. They have different claim numbers. From
Yeah.
a death benefit claim has a
But
different
to
claim
follow
number.
up on the judge's questions, I think that there's a conceptual error in that argument. Liability, and this is constantly discussed in all forms of negligence, in negligence laws, in personal injury law, it's very common. The way I understand it is liability is you have a duty, you breach the duty, and then there's proximate cause connecting the damages to the duty that has been breached. Here, the liability part of this, the portion of this has been established, and the claim that comes forward are the damages. I have a claim for death benefits. I have a claim for an injury over here. I have a claim for lost wages. Those are claims, and the legislature seemed to be very careful in laying these out. And that conceptual distinction, I think, the way I read it, seems to be at the core of the third department's decision. What they're saying is, okay, they've established liability now. This is in here. So when you come up with each new claim, there's not separate liability that had to be established. That's an element of the damages that arose through the liability.
I don't agree with that analysis, Your Honor, because liability is different for a disability claim than it is for a death benefit claim. When you're looking at liability for a disability claim, you're looking at whether or not the injury is causally related to the underlying
Right, that's
accident.
proximate cause.
Right, but when
That's
you're
not
looking at
different.
the death, you're looking at whether the death was proximately caused. So,
Of course.
if a claimant, for example, was hit by a car, as opposed to died here, in both cases of organ failure,
Mm-hmm.
that would be a totally different analysis here. So liability for each claim
Those
ha-
are all
has a different
proximate
analysis.
cause questions, but the original liability that's set up for a duty that was breached and established a responsibility, and the establishment of that responsibility occurred within the statutory framework. This is the way that I read the third. That's the way they're arguing this. And once that's established in there, that the claims that flow, or the allegation of a claim that flows out of it, if it's proximate cause, if it can be connected to that liability, they're responsible for it, because the liability was established within the statutory framework. That's the way I read this. To do otherwise would mean that every time you have a damages claim, you would have to reestablish a duty and a breach of that duty to go forward, and that's not what this is saying.
Again, I want to push back on that, Your Honor, because
Sure.
they're referring to claims here. These are entirely separate claims, as this court said in Zeckman. They have different claim numbers. They have entirely different beneficiaries, so they have different elements. It would be like a personal, in a car accident, it would be a personal injury claim, and then like a wrongful death. There's different beneficiaries, different dates of accrual, different claim numbers.
Right, but the liability will all be established at the time of the car accident. And I think that's what I think that's what your argument misperceives.
Well, in fact, it won't, because that liability is different. The liability is whether or not the death is causally related versus whether or not the injury is causally related. They're two different analysis on liability.
Here's my problem still with liability versus claim. We have said it's a different claim. The death claim is a different claim. But the way I read it, and I just looked at it again, Fitzgerald says the liability for that death claim, separate as it may be, the liability passes to the fund at the time the case goes over there and the initial benefits are paid. So no one's, under Fitzgerald, no one's transferring liability for that claim, new claim though it may be, no one's transferring liability for that claim to the fund after the date of the closure. That's how I read those cases together.
Yes, and that would make sense, Your Honor, if that claim had yet accrued. But basically, there's no way to square that with this court's decision in Zeckman, because that claim does not yet exist.
So do
And
we
that
have to
claim might never
decide
exist.
that? Do we have to decide whether Fitzgerald's right or wrong here?
I think a correct decision in this case would have to abrogate the decision in Fitzgerald, and it should, Your Honor, because again, there's no way to possibly square this court's very unambiguous language in Zeckman with the language of Fitzgerald, because that death benefit claim even if it arises out of the same injury as an already transferred lifetime benefit claim, has not yet accrued at the time of that transfer, and in fact may never accrue.
Can I just go to Zeckman for a second?
Please.
I had thought that in Zeckman, that the issue of whether the death claim was properly assigned to the fund was not in dispute. The only dispute there was whether that claim was time barred. That was the only dispute in Zeckman. It's
Well,
not,
because-
excuse me, the way I read it is it's not the same issue as the issue we have here.
It wasn't an issue there because it hadn't, because it otherwise met the requirements, Your Honor. So the special fund wasn't denying liability,
Yeah.
but it wasn't transferred simply because the lifetime claim transferred. And in fact, that's exactly why Zeckman is so controlling here, because if they just went together, right, if they just went automatically together, this court wouldn't even have to analyze. If it was just automatic, that the lifetime benefit claim and the death claim went together automatically to the special
No,
fund.
you're misunderstanding me. I don't think they go together automatically. You still have to establish proximate cause. The question is the date of liability when the duty was breached. And that is the liability that's being referred to in Fitzgerald. And it seems to be a fundamental disconnect here between those two concepts.
But Zeckman, the claim hadn't gone over. Zeckman, the claim was from the 50s, the insurance company paid it. So it wasn't that that claim had been paid out of the fund before. It wasn't a Fitzgerald situation. It was just those deadlines, those 8/18, whatever those timeframes are, is that going to apply to this new claim that's now going over? But Zeckman is not this. Zeckman, the fund didn't have the original claim. And I think that's what you were just saying, that Zeckman, the fund, had the original claim, so why would they consider it? They didn't. The 50s claim was paid by the insurance company.
I believe that's right, Your Honor. And so in the fact that the death benefit claim in Zeckman was a separate and entirely different claim was controlling there. And so it has to be that's true
Claim
here as
versus
well.
liability again. See, in Zeckman, they didn't have the liability for the claim because the insurers paid the original claim. But in this case, arguably, they have the liability already because the fund has been paying the earlier Zeckman-type damages.
Well, I'm having trouble remembering in Zeckman whether or not the initial claim was paid by the fund. I believe, actually, I misspoke, that the initial claim was paid by the fund there. And that's why Zeckman, again, is controlling, because otherwise, if they both went over together, you know, that would change things.
The initial claim in Zeckman was 1954, so was the fund in operation then?
The fund was enacted in 1933, Your Honor. And the reason why the fund was enacted in 1933 is because there was this idea that insurance companies needed to be, covered for these unanticipated liabilities. But since then, in 2013, the legislature unambiguously closed the fund to new claims. And the reasoning there was that it was no longer needed to protect workers from insolvent claims because there were other mechanisms put in place. And also because at this point, the insurance companies were double dipping. They were collecting sufficient money in their premiums to cover these diverted claims, and they were also passing the assessments to support the fund onto their...
But again, I hate to beat this to death, but in Zeckman, the injury is 51, the last payment is made in 55. So how would that ever be in the fund?
I have to look back at Zeckman, Your Honor, but I'm sorry, the last payment, because it's, I'm sorry, no, it was in the fund, because it was only it's 3 years from the last date of the claim, from the last date of payment.
Yeah, but if the injury
So
happens
that's
in
4 years, Your Honor.
51 and they're paying 51 to 55, how does that go into the fund?
They're paying from 51 to 55, Your
Right.
Honor?
The last payment's made in 55.
The last payment was in 55. I believe there's three, in Zeckman, there's 3, I'll have to look back before
okay.
rebuttal, but I
I'll look
believe
at it.
there's 3 years in between the last payment, such that the claim went to the special fund, Your Honor.
Okay.
Well, I have to say that I had my notes on Zeckman and questions, and I asked you some of the questions, but I have underneath there, not sure about the facts. So it's we'll have to go back and look at it.
Okay,
Yeah.
Thank you, counsel.
thank you.
Counsel? Oh, you're back here.
Good afternoon.
Good
May it
afternoon.
please the court, I'm Matthew Mead for the Special Fund. Picking up on the Zeckman line of discussion, my recollection of Zeckman is that the issue was whether the claim for transfer was timely in the sense that the special fund questioned whether the board still had jurisdiction to reopen that claim. And when we consider that the claim was initially 1951, last payment in 1955, 1955 is the beginning of the count date for the 3 years since the last payment of compensation. So the claim had to be reopened at some later date, much later, and the fact that it was, well, much later in the case of Zeckman, because it was beyond 8 years from the last payment of compensation and beyond 18 years from the date of injury. So this court resolved in that case that the claim would not be time barred because the death claim is a separate claim. Now, I don't know whether I'll have time to really get into the negligence analysis, but I think it's misplaced. If you're going to analyze this as a duty, breach, causation, and damages,
No, what I was trying to say to you, what I was trying to do is say, what do we mean by liability?
yes, sir.
Yeah, that's what my argument, poorly given as it was, is what do we mean by liability? And here, liability means the same thing across all forms of personal injury in whatever way it crops up. And the language in the legislature does not equate claim with liability. That's not what they're doing with the language there. These things are finely crafted, and you deal with them more than I do, but it seems to me clear that the word claim is not equivocate, is not the same, is not equivocal with liability. It's not equal to liability. That's incorrect.
Yes, but the liability is that of the employer.
Right, so,
It's
well,
not that of the carrier, it's
When
not
you
that
take,
of
when
the
you
special
assume
fund.
liability for the claim, for the injury, which is really the correct way to do it, that's the date that matters in terms of whether you come before the deadline. And then the statute that sets out a process by which you may assert a claim, which is a claim based on liability that exists and that has existed in this fund.
The you that you're referring to, sir, you mean the
I mean the
carrier,
claimant.
the initial
Yeah,
payer of
Right,
compensation?
the claimant,
Asserting a claim for reimbursement from the special fund.
right,
That's
Mr.
what we're
Mead,
talking
right?
Yes, sir.
Yeah, Mr. Mead, that's what I mean, yes.
Okay. Well, it is possible that the word liability is misused in this context, and it is
I see the word liability as responsibility. And that, this is, I don't expect somebody to give me an answer standing there on their feet if they haven't really thought about it, so that's not fair. I'm
So-
not asking for that. What I'm just saying is that that's how my understanding of what the third department's analysis and the underlying legislative scheme was based upon.
So if you're talking about the third department's analysis in Fitzgerald and Mosqueda,
Yeah.
I think that they improperly leveraged some language from this court in the DeMayo case. And the reason I think it's improperly leveraged in Fitzgerald and Mosqueda is that DeMayo was not a death case. DeMayo had nothing to do with the issues, but it had a great little soundbite that once Once liability is transferred, the carrier has nothing more to do with the claim. But,
But counsel, just to stop there for, I'm sorry, 1 second.
yes, sir.
After Fitzgerald comes down out of the third department, and I think we deny leave, but anyway, it never gets here. What's the practice of the fund with respect to death claims on cases where they had been paying benefits out to previously?
I think the analysis differs depending on when benefits were last paid, because remember that Section 25A1 enumerates 3 circumstances in which the fund becomes liable. The third of those circumstances is death occurs more than 7 years from the original injury. And so that's an independent basis for establishing liability, for transferring liability from a carrier to the fund in a death case. There's a statutory provision that does that. And my experience, you're not going to find this anywhere in the record, but my experience is that most of these things were done informally. There would be a letter to the Workers' Compensation Board asking for an administrative adjudication of 25A liability is how we referred to it. And the board would communicate with the special fund, at that time administered by the Special Fund Conservation Committee, asking whether they would accept liability or not accept liability. I don't know that a lot of these cases were litigated. As a matter of fact, I can't think of a case in my time that was litigated on that question. The special fund had an expertise in what Section 25A said. The special fund took a lot of cases up to the appellate division to define what that statute said. And in many cases, they would simply accept the transfer of liability.
Thank you.
So,
Thanks. It makes some sense. Yeah, and the evolution of it.
yeah,
That's
yes,
helpful.
sir.
Thank
So fundamentally, I'm sorry, my time is up, but fundamentally, the legislative intent in 1933 is different than the legislative intent in 2013. The legislature intended to make a change in this statute and how it was administered, intended to close the special fund for reopened cases. That's what we're asking this court to ratify. Thank you.
Thank you, counsel. Counsel?
Good afternoon.
Good
May-
afternoon.
May it please the court, my name is David Faber. I'm the attorney for the self-insured employer, Consolidated Edison, the respondent in matter of Verneau. What we're dealing here with 25A1A is precise language in a statute. It's our contention, and based upon Krause in 2011, the third department, the clearest indicator of legislative intent is the statute's text and the language itself.
Right, so counsel, if I can interrupt you, please. So 25-A, 1-A, which the operative language we're dealing with here, is transfer of liability of a claim to the fund. You have to look at the claim.
Forgive me, Your Honor, you broke up at the end there.
Oh, my apologies. Regarding the 25A, 1-A, that says transfer of liability of a claim to the fund, that to determine the liability, you have to look to the claim, correct?
Yes, Your Honor. To the original
Okay.
claim, yes.
So, well, where does it say original claim? It just says claim. Isn't it the claim you're trying to transfer?
Well, no, Your Honor. It is a death benefit claim, but it's part and parcel of the underlying accident or injury, which in this case was in June 1st of 2000. And
But that again, it doesn't say liability for the original disabling event. All it says is liability of a claim. And so you have to look at the claim to figure out the liability. And if we have said that death benefit claims are separate and apart and distinct from the original claim for disability, doesn't it follow that this is exactly as is argued by the board?
I don't believe so, Your Honor. It is true that in Zeckman, there is that language to the effect that disability and death are distinct, legally distinct, different accrual dates for statute of limitation purposes, but death is not a new injury or accident. Death is a new claim consequential to the original. That's stated in Krause in 2011, the Third Department, the Commissioners of the State Insurance Fund in 2009. And once 25A has been triggered, this court said this in DeMayo, the special fund steps into the shoes of the carrier and succeeds all of its rights and responsibilities. And it has always been handled in the appellate division and in the relevant case law here that when you have a consequential injury, that would be the liability of the underlying claim. If it was a consequential stroke, it would clearly be it'd be a claim for a stroke, but it would be the liability of the underlying claim, whether it's a date of accident or a date of disablement. In this case, you have a consequential death. You have a new claimant, if you will, and it is legally distinct, but it has been found that this is not a new and distinct injury or accident. It is consequential to the underlying injury. And in this particular
But
claim,
counsel, I think this is Judge Rivera's point. She's reading the statute, and it doesn't say liability for an accident. It says liability for a claim. And she's pointing out, I think that the only way to reconcile that is to say that, as Zeckman said, the death claim and some earlier claim are two distinct events.
they're two distinct events. They're legally distinct as far as accrual dates for statute of limitations purposes. That's what Zeckman was talking about, the statute of limitations in Section 123 of the Workers' Compensation Law.
Would you at least agree that had the statute been written to say transfer of liability for an injury or liability for an accident, we wouldn't be here?
I think if the statute specifically said a claim for consequential death due to an underlying disability matter where the special fund was already deemed liable would not be part of the special funds at this point, that would be something. But
Yeah,
that's not what the statute
I'm asking you
states.
something a little bit different, so you can answer my question, which is if we substitute the word accident or substitute the word injury for claim, wouldn't it be a lot clearer?
I believe so, Judge.
Okay.
Judge, I would note, though, that the legislative intent here I don't believe is in question, frankly. The memorandum in support of this amendment of the statute and the statute language itself does not go against what the respondents are arguing here. There is clear and unambiguous statutory language. At no time did the respondent here make an application for transfer to the special fund. There's case law that supports our position as well. This court said in DeMayo that once Section 25A is triggered, the special fund steps into the shoes of the carrier and succeeds all of its rights and responsibilities. That would include any consequential injury, including a consequential death. I would note that the Appellate Division 3rd Department in Mesquita got it right. That's our contention anyway. They clearly took notice of the history here and made the determination that where liability previously was transferred to the special fund in a disability claim, the special fund will remain liable for any claim for consequential death. If you look at the history of Mesquita, when it went through the appellate division process, the board agreed with us at that time. Exactly, they were agreeing with us throughout the entire Mesquita arguments, but because of your decision in American Economy in 2017, they all of a sudden rejected the Mesquita finding, which made no sense to us, frankly, because at least our interpretation of your decision in American Economy was that you rejected a constitutional challenge to the amended statute. But you did state in American Economy that the special fund remains open to administer cases that were previously assigned to it. That's exactly what we have here. We have a claim that was previously administered by the special funds with a consequential injury. So we would contend, Your Honors, that there was no violation of the statutory sentence at issue. There was no application for transfer of liability. And none was needed, frankly, because a consequential death is not a new accident. It is not a new injury. It is a new claim consequentially related to the original injury. There is no language in 25A1A that suggests the board should reject long-standing legal precedent. If the legislature wanted this to be the case, it would have stayed the same in a clear and unambiguous manner.
Thank you, counsel.
Thank you.
Counsel?
Good afternoon. Glenn Chase with Walsh & Hacker on behalf of the State Insurance Fund and its insured in the matter of the Rexford claim. So we do have two claims that basically the same fact pattern. similar fact patterns to all of the cases we've been discussing involving transfer of liability to the special funds. We have Section 25A1, which allows for transfer under 3 circumstances. The first one doesn't apply because this is a claim that was established, or both these cases were established and resolved. Section A1-2 applied in both of these instances. That's why 25A liability was fined with respect to the underlying claim. That requires 7 and 3 years from the date of injury, 7 years from the date of injury and 3 years from the last payment of compensation for the transfer of liability. If you take those facts and you look at the case law that has been promulgated all the way back to 1971 in Ricciardi.
Counsel, if I may ask, how, let's say the court agrees with your view, how does that further what is clearly the legislative purpose? We quoted it in American Economy, it's obvious from the legislative history, to avoid the windfall that the legislature had determined carriers and employers were enjoying based on the state of the law before they closed the fund.
Well, I think that the American Economy also has a very specific statement in it, and that was that it was to close claims for new transfers, not cases that had previously been transferred. And as found by the appellate division below, and as argued in our briefs, this case was previously transferred.
Tell me, Counselor, if we were to rule in favor of the compensation board, would we be overturning both Fitzgerald and Mosquito?
I believe you would be, yes.
Yeah.
And you had asked, I believe, the question earlier, what was the board's practice after Fitzgerald? It's practice, and it's the same practice that happened in this instance. Neither carrier made an application in this instance. The board's practice, based on Fitzgerald, which it affirmed in Mosquito, was to index the claim and bring it against the special fund. The special fund was named as the party. They said, we're not liable because of 25(1)A in our claim. At a hearing, we were put on notice. Once we were put on notice, we then said, no, wait a minute, this claim is already transferred. It's not our liability, and that word was used previously. So our position has been, and in accordance with Mosquito, was that the liability transfer, and as noted by Mr. Faber previously, it is not a new claim for liability purposes. It is a consequential claim to the original injury, and that's
Well, you know,
discussed.
part of the confusion, and Judge Wilson hit it right on the head, part of the confusion is the terminology that's used. It means different things in different areas of the law. And one of the reasons I'm always trepidatious when dealing with these third department cases because they deal with this language all the time, and sometimes if it's not your life, you might not deal with it with the same way. And so that's why I asked the overturning question, because it's an area that we have to, if necessary, of course, we will overturn it, but it's a finely tuned engine.
Counsel, here's my concern about Fitzgerald and Mosquito. Both, Fitzgerald is a 2011 case, Mosquito sometime before that, I think. And these are pre-closure cases. The special fund was closed in 2014. And I feel like when we talk about what the common practice was, like you said, after a claim was accepted into, or after a case, whatever it is, was accepted into the special fund, the death claim would automatically get indexed to the special fund. It was just the custom and practice. And I wonder whether the decisions in those cases incorporated the understanding pre-closure that once a case was assigned to the special fund, all subsequent claims would go there pretty much automatically, and that if these cases had been decided after 2014, the decisions may have at least looked different than the way they do.
Well, if I may, Your Honor, Fitzgerald was decided in 2011 before the amendment to the statute.
Right.
Mosquito was filed after 2014. It was a date of injury after 1/1/14. In Mosquito, the board had taken the exact opposite position it's taking today. They accepted that in accordance with Fitzgerald, again, as Mr. Farber made the same argument, I apologize for repeating things. After Fitzgerald, the board had that policy, they established it, they indexed it against the carrier, against the special funds. They continued that after Mosquito in January 14, which is why we're here. We objected and said, no, liability was already transferred. In Mosquito, there was the same thing, the same facts as...
But counsel, aren't they bound by, since we had not ruled, aren't they bound by the appellate division's law? I mean, I'm not sure I'm understanding your argument. Are you saying they should have taken the position in Mosquito that the appellate division should have reconsidered its view?
I apologize, Judge, I don't mean to cut you off, but they could have and should have appealed if they did not believe that that case was appropriate. They didn't. The only reason we're here today is because, as the court said, or the board said, we find American economy controls, and since American economy is constitutional, then we're closing the fund, and that applies to this case. That was the board's rationale before the court and why they were denying the application here. It was not anything to do with, was this claim previously transferred? It was, and that was the court's rationale.
Oh, so counsel, if we thought they were correct on the statutory interpretation as they've advocated, are you saying that because they took a different position that we could not decide now that the statute reads as they advocated reads?
I can't say that. You, of course, can make a different decision in your interpretation of the law, Your Honor, but I think that it goes to the merits of our position that this has been the policy and the procedures and how the board has acted on these types of claims and this same issue.
And counsel, weren't they acting that way when the legislation passed? When the legislature did this, we assume the legislature and certainly this fund knew that's what the practice was, and they wrote the legislation this way.
Exactly, and I think that was my second point, and it was, I think, part of Mr. Farber's point, is they were aware of Fitzgerald when they wrote the law in 2013. They didn't change, they didn't specifically carve out an exception to Fitzgerald in the statute. And again, I didn't get to say it earlier, and I know my time is up, but Zeckman is a very interesting claim because the fund conceded liability under Section 25A1, the 7 and 3 year portion. Again, the only issue raised in that claim was whether there was the statute of limitations applied. And they attempted to argue that that death claim goes back to the original claim. And the court said, no, they're different proceedings. And this goes to another question or words. It seems that the board, the court, have used words interchangeably, proceeding, claim, and that has led to some of the confusion. But I think the bottom line is the liability issue. And the court has been very clear that once the liability transfers, and this court is well into Mayo, the special fund steps into the shoes and they remain liable for the claim, whether it be a penalty case into Mayo or payment of benefits for death, a consequential death, as in these claims.
Thank you, counsel.
Thank you,
Counsel?
Your Honor.
The entire reason why the board moved away from the language in Fitzgerald and Mosquito is because this court's decision in Zeckman is controlling, but also because once this court came down with the decision in American economy and made it very clear that the legislature's intent was to close the fund as expeditiously as possible, there was no other conclusion except to determine that these claims, these death benefit claims, were new and separate claims that could not be transferred to the fund after the statutory closure date of 2014. And that comports well with the legislature's intent here. Under respondents' reading, the fund would have to stay open to new cases for 2 years after the last lifetime beneficiary.
Counsel, let me ask you something, please. In the statute, again, that language, for transfer of liability of a claim to the fund, could the legislature have written that for transfer of liability to the fund? Because it seems to me that that is what is being argued that this means. Would it have written it that way?
Well, it didn't. It said transfer of liability of a claim. The fact that they.
No, I understand. My question is, if the real intent of the legislature is to say, or if what the legislature understood is if someone's, if the disability benefits had already been transferred, then of course the consequential death benefits will also follow that. Could it have just written liability?
Yes. If
And that would suggest a new claim?
If that's what the legislature intended, then yes, they could have just said liability, but they said liability of a claim. And so the legislature is attempting to say that liability of a new claim cannot be transferred. Death benefit claims, as this court has repeatedly said, not just in Zeckman, but also in Horonic, are.
How would your interpretation of the statute change if liability wasn't in there? If it just said transfer of a claim, would that be different?
I don't think so. Liability here, it just means
No, but
responsibility.
let's just stay with that first. So if you drop liability from the statute and it just says transfer of a claim to the fund, how does your rule change?
I don't think it does. I think it's.
So then why would you put liability in there?
Well, I think it's more precise, transfer of the claim or transfer of liability for the claim. But either, it's saying who's on the hook for that claim. It's
then
transferring the claim or
But I
transferring
think it's the
liability.
reverse argument, right? So if you wanted to just say claim, and this is a new claim, any transfer of claim is barred, they knew we called it a new claim, but they didn't say that. They said transfer of liability for a claim. So liability has to mean something.
Well, liability means, whether or not the death was causally related to the underlying injury. It's a matter of whether or not they've made out their case for liability, or the special fund also has
If they didn't make
other.
out the case, nothing transfers, right?
I'm sorry?
I mean, if there's no liability, like nothing transfers then.
Right.
Like to transfer liability for a claim assumes there's a valid claim there, right? So it's the liability on that claim that they're getting at, not the claim itself. And that's, I think, what I'm having trouble with your rule.
Well, it's both. There's liability for a disability claim and then liability for a death benefits claim. They're separate and apart from each other.
Yes, but I think Fitzgerald said that liability, once you get the first, you get the second.
That is what Fitzgerald said. But again, that language simply can't be squared with this court's decision in Zeckman, and again, with its decision in Horonic, which said the same thing, that death benefit claims are separate claims. And that makes sense under the legislature's intent here, Your Honor. If respondents' reading is correct, that would mean that the fund would have to stay open for 2 years after the last lifetime beneficiary has died. And there are more than 9,000 current lifetime beneficiaries. So the fund, that would mean that up to 9,000 additional new claims could still, that have not even yet accrued, Your Honor, could still be transferred to the fund well after the 2014 cutoff date. And that simply cannot be what the legislature intended here. It's contrary to the legislature's intent to pass on 9,000 additional new claims to a fund that was supposed to have closed in 2014, and to end these assessments. The assessments this court said in American Economy that the assessments at that point were $95 million. In 2006, they were $95 million. In 2020, those assessments were $425 million. The legislature intended to end those assessments and to stop this huge windfall that insurance companies were getting. And if those 9,000, even a fraction of those 9,000 claims are allowed to accrue and then be transferred to the fund, not only would the fund have to remain open for the lifetime of all the current lifetime beneficiaries, but also for the lifetime of all of their survivors.
Counsel, I just want to be clear about something you said before. Let's just stick with the number that you have. Are you saying, though, that in each of those, in whatever case that a survivor wants to claim death benefits, they're nevertheless going to satisfy the elements of causation and show that indeed it is causally related to the underlying events that led to the disability?
No, you're right, Your Honor, that's fair. I mean, it would likely be a portion of those 9,000 claims. I mean, there's no indication that all 9,000 claims would become new death benefit claims that would transfer to the fund. But if...
No, yes, I get that, but I'm saying that whoever seeks this transfer still has to, the survivor, there's still going to have to be a showing of that causality, correct? Yes?
Yes, of course, Your Honor. And in fact, in both cases, in Rexford and Verneau, those issues were heavily litigated, whether or not the way that both men died was causally related to their underlying...
Because I just want to, I may have misunderstood the other counsel, but it struck me that their argument was in part, the whole case, not liability, it's the case, not the claim, that's transferred, everything flows from it. If the employee dies, you're going to get death benefits anyway. I may have misunderstood them, but I was concerned that perhaps you were seeing it the same, and it struck me you had said something before where you left an opening that indeed there could be a challenge to this causality.
No, the case doesn't transfer. All that transferred in both cases here was the lifetime benefit claim. Nothing else transferred at the time that the lifetime benefit claim. And the reason is because a death benefit claim, again, is an entirely separate claim and has a different claim number, different beneficiaries, a different payment structure. It falls under a different workers' compensation law section. So it simply can't be that anything else transfers at the time of the lifetime benefit claim. And the reason is also because that claim has not yet even accrued. At the time that the lifetime benefit claim transferred to the fund, the death benefit claim has not accrued and may never accrue depending on how the underlying individual passes away, or if their loved ones even seek benefits, the claim might never even accrue.
Well, the claim might accrue at the point of death. Whether or not they can substantiate the claim and their right to the benefits is sort of a different story. But if I'm understanding you correctly, your argument is that even upon death, that doesn't mean that there's going to be any benefits paid out, because there still has to be determination that there is liability for that death. That is to say, you've got to establish the causality.
That's exactly right, Your Honor. And I'm also going a step further to say that someone might not even apply for death benefits. So, that claim just might never lie because it's not clear that a loved one would even seek those claims. That's something that, surely cannot be anticipated at the time that the lifetime benefit claim was transferred to the fund. In this case, one was transferred in 1997 and the other in 2011. And at that point, neither the legislature had not spoken, nor had this court spoken in American Economy. And again, in American Economy, this court made it very clear that the fund should close as expeditiously as possible. And under our reading, it would be allowed to do so.
Thank you, counsel.